Hello and welcome to Rise Ice YouTube channel. My name is Devato Shaha, and in today's editorial explain video, we are going to talk about this article. The title of the article is Just Truth. Just and Just Truth. The article is all about the DNA test for paternity, which will decide the ultimate identity of a child. Therefore, this article becomes very important for UPSC, especially under GS paper 2 Polity. And related idea, if you stretch, you can stretch it to GS paper 3, the idea of science and technology of DNA, how DNA works. Now, from this important article, which somewhere directly or indirectly affects each one of us who are watching this video, will affect now or in effect in future. Therefore, it again becomes important for our preparation. Therefore, our team at Rice IAS has prepared a holistic article based on this judgment, keeping in mind its constitutional principles. How has the idea or this concept has evolved till now? The challenges associated with this judgment or this idea DNA testing, and what can be its way forward with conclusion, a ready-made answer format content. Now, the title of our article is somewhere DNA testing in paternity dispute. This question is going to somewhere help us to understand how this content is going to evolve or this content is all about through a mains model question. The Supreme Court has evolved a nuanced approach in ordering DNA test in paternity dispute, balancing scientific truth with privacy and dignity. Discuss in the context of post-Puttaswamy jurisprudence, 15 marks. So once the question is in your mind, you can draw the horizon of this topic. Now, keeping that in mind, let's jump in the content. The very first part would be the context. We see CP versus AP judgment of 2025, where Supreme Court held that DNA testing in paternity dispute should be ordered only and only as a last resort when other evidence are insufficient. Okay. We understand that there is a judgment by Supreme Court where Supreme Court reaffirms the fact. Why I'm speaking reaffirming the fact, we will just see after a few minutes. But Supreme Court reaffirms the fact that the DNA testing as a proof of parent would be the last of the last resort when it is of utmost importance. Now, when we have understood the context, before jumping directly to the challenges, way forward and conclusion, let's first see what are the core principles associated with this judgment or this idea. The first would be, as we all know, right to privacy, Article 21, where the genetic information forms a part of informational privacy and bodily autonomy, both for the child and for the parents under the Puttaswamy judgment. Next, it also affects somewhere right to know one's identity, who are his or her actual parents, or is that my actual child. Individual have a legitimate interest in establishing biological paternage for identity, inheritance and emotional well-being. Second, if we see from the perspective of dignity and the best interest of the child, we will see the law seeks to protect the children from the stigma, the discrimination, the social harm which arises from the illegitimacy tag or the illegitimacy claim in the society, by providing it as a legitimate child. And at last would be the interest of justice associated with it. where the court must discover the truth while ensuring minimal infringement of fundamental rights in place. Next, if we see the legal framework associated with this idea, we would see the Bharatiya Sakshya Adhiniyam, Indian Evidence Act, formerly known as 2020 post 23, prior to 23. It somewhere categorizes the procedure into some aspects. It says child born during a valid marriage is presumed to be legitimate. No need for a DNA testing. It is prima facie believed that it is legitimate. But if someone is opposing that fact, the burden of proof goes to that person. That burden of disproving paternity lies on the person challenging the legitimacy. Next, the pre-assumption somewhere protects the family stability, child dignity, and as well as the privacy in place. And pre-assumption can be rebutted only through a strong, compelling evidence only. Now, if we see this idea is somewhere not going with this concept, but also going with this concept, how we will see in later half only. But before that, let's see the evolution of this jurisprudence by the Supreme Court. How has Supreme Court periodically or over the period of time has evolved itself through this judgment? In the phase 1, we see there is absolute protection of legitimacy and a restrictive approach of DNA. Under Gautam Kundu, we see DNA test cannot be ordered routinely. A strong prima facie case is necessary, just as the Bharatiya Sakshya Adhiniyam. The next goes Sri Bansari Bansari Das case, where scientific test should not be used as a merely to satisfy curiosity of the society or a person, where we get to see the focus is on protection of the legitimacy and the family's stability through this judgment. Then comes the second phase, which recognition of scientific truth. Yes, we do recognize that prima facie it's a legitimate child, but now we steadily in the phase 2, Supreme Court steadily accepts the recognition of scientific truth under the Rohit versus ND Tiwari case, where court accept DNA evidence despite privacy objection in place. Even in the Vasudev case, we see scientific truth prevails over the legal pre-assumption when the conclusively established. And the Roy case also refusal to undergo DNA testing may invite adverse inference has been observed by the Supreme Court. Therefore, through these three judgments, we get to see that through discovery through scientific evidence is somewhere recognized by the court of law, the highest court of law. And now, if we see the phase 3, we see again a privacy-centric constitutional approach. Again, Puttaswamy judgment, where privacy recognized as a fundamental right under Article 20, which again DNA testing must satisfy the legality, legitimate aim, and the proportionality triad in place, which again focuses on privacy, more privacy, autonomy, and protection of genetic data. But now, the phase 4, which somewhere tries to balance the truth, scientific truth, and privacy, where Ajinkya Firoda case, we get to see DNA testing should be ordered only when alternative evidence is not available. Even in the Irwan case, we see neither privacy nor rights are absolute stated by the constitutional court, which again solidifies the idea that there is nothing fixed. There is no absolute privacy in place. We can go for DNA testing if required. And in the recent judgment of 2025, we see CP versus AP case where DNA testing is permissible only and only when necessary, proportionate, and indispensable, absolutely needed for the justice to prevail. Now, the current position somewhere recognizes the DNA testing as a measure of legitimacy, but as a last resort. Okay, now once we have seen the evolution of the judgment, now we can properly address or point out the challenges associated with this idea and the way forward. The first challenges associated with this issue would be privacy concern. Well, compulsory DNA testing may violate the bodily autonomy and informational privacy as somewhere prevailed by the Puttaswamy judgment. Impact of on child dignity. Somewhere paternity dispute can cause stigma, emotional trauma, and family disruption in the society. Legal presumption versus scientific truth. Conflict may arise between legitimacy presumption and conclusive DNA evidence. The need can be somewhere be shift to want from preassumption to wanting to a legitimate conclusion. The ethical concerns associated with it, the question of concern, misuse and storage of genetic information remains unsolved. Till now, it's an ethical concern. Judicial subjectivity is also at question, where interpretation of necessity and proportionality may vary across multiple courts, multiple benches also in the same court. Now, once we have seen the challenges associated with it, now let's see the what can be the way forward of it. The first would be the DNA testing as a last resort, as stated in the AP recent judgment, where court should exhaust all the alternative evidence before directing the DNA test. There should be strong data protection, keeping in mind the Puttaswamy judgment. There should be a robust safeguard are needed for collection, storage, and use of genetic data. Child-centric approach. Welfare, dignity, and psychological well-being of the child must remain paramount importance. And uniform judicial guidelines, where standardized criteria can ensure consistency in judicial decision across the court, across the benches. Even strict application of proportionality, where DNA testing should be the least restrictive means available. And again, confidential proceeding, not only keeping the data, but the proceeding should ensure confidentiality, where paternity dispute should be handled with complete confidentiality, so that the burden and the stigma has not to be borne or the borne by the parents. Now, ending with a conclusion, a short crisp conclusion which will give a complete idea of the content. In the constitutional democracy, scientific certainty cannot become a justification for rights infringement. Article 21. But truth must be pursued through the lenses of dignity, privacy, and justice, keeping in mind the scientific temperament only when we follow the way forwards in letter and spirit. That was all for this session, this important session. I hope this session was indeed helpful for your preparation. And if you feel so, I would like you to like this video and subscribe to Rise IAS YouTube channel. And yes, among you who are wondering where can I get this PDF from, you can get this PDF from Rise IAS website in absolutely free terms. Once again, I thank you all for joining this session and keep preparing.